Why?
Morning, everyone. Welcome to the Judiciary Committee meeting this at 9:30 for the 9:30 agenda. Sorry about the late start. We had some technical difficulties that I believe are now worked out. I'm Carl Rhodes, the chair of the committee. On the video conference with me is Jarrett Kalola, who's vice chair. Members Mike Gabbard, Donna Mercado Kim, Laura Acasio, and Kurt Favela are all here. I don't see Senator Lee, but he's also on the committee. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Tuesday, February 9 at 9:10 a.m. and a public notice will be posted on the legislature's website. For all the people testifying remotely, all testifier audio will be muted and video disabled until it is your turn to testify. There's a 2-minute time limit per testifier, and there's a little clock that you'll be able to see on the screen so you know when you're running out of time. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person due to time constraints, but we will try to come back. We appreciate your understanding and remind you that the committee has already received your written testimony. I will be reading a list of people who submitted written testimony for each measure. I apologize if the closed captioning doesn't accurately describe the names or if I mispronounce them. If you're interested in reviewing the written testimony, please go to the legislature's website at www.capitol.hawaii.gov, capital with an O. You will find a link to testimony on the status page for the measure. And members, we will wait, just per normal procedure, we'll wait until the end of the testifiers to ask questions. Okay, first up today, we have Judiciary Communication number 9. This is for consideration and confirmation to the District Court of the Second Circuit Judicial nominee Christopher M. Dunn for a term to expire in 6 years. Okay, we have a lot of testimony. Because it's a remote situation like this, I'm going to go ahead and read everybody's name, but there's only one person that's signed up to actually testify in person. Testify remotely, but we'll try to make this as a real experience as possible. So here's the names, and I'll go as quickly as I can. First, and everyone's in support. Everyone's in support. Jennifer Lopez, Health Services Administrator, Department of Public Safety, Maui Community Correctional Center. David Kane, Law Office of Kane and Heron. Richard Grona, also an attorney. Margaret Murakami, Senior Probation Officer, Adult Client Services. Ku'ule Inani Maunu Pau Gaspar, testifying for Ka'ehu. Ben Lowenthal, Wendy Hudson, Lance Collins, William Sloper, Pia Aluli, Peter Horowitz, Elizabeth Kuchia, Matt Daniels, Jeffrey Wolfenbarger, Alan Alameda, Byron Fujieda, Jan Apo, Graham Matola, Jacob Lowenthal, John O'Neill, Mercedes Obregon, Chris Pogdelau, Joshua Kent, Ryan Anderson Tashima, Heather Wolfenbarger, Maui Deputy Public Defender, Patrick Brault, Frank Zayach, David Hayakawa, Peter Konohia, Jennifer Konohia, Quentin Cutie, Richard Singh, Madhuri Vijay, Adriel Manor, Paul Mancini, Wendell DeVera, Jamal Aruri, Clarence Virtue, Blake Kropf, Albert Albrechtson, Sharon Baladoy, Gina Gormley, Pamela Schultz, Dana Souza, Brad Sova, Eric Rohozinski, Joseph Toma, Damir Andrew Kuliev, John Harrison, Mark Rophorst, Kara Kaiulani Galone, David Zambrano, or Davida Sombrano, sorry, Greg Okamoto, Captain of Maui PD, Aaron Lowenthal, Stephen Hartunian, Matthew Combe, Kalani Ho Nikaido, Sam McRoberts, Danielle Sears, Brandon Siegel, Chelsea Evans, Susan Gushikin, Barbara Sauer, and John Liu, all in support. And we have next Levy Ho'okano, HSBA President, testifying for the State Bar Association. And I think he was planning to be here. Are you here, Mr. Ho'okano?
Hi, Senator. He is currently not in the room at this time.
I'm sorry?
Hello, Senator, this is Jesse Faig. I just received a message from Levi Ho'okano. He is having difficulty connecting. He said if he is not able to connect, he stands on his testimony that the appointee is qualified.
Okay. Well, apparently we're not going to hear from him. So yes, HSBA has determined that the nominee, Mr. Dunn, is qualified. And that's all the written testimony we have and all the testimony we have. So Mr. Dunn, if you'd like to make an opening statement, we don't have anybody to ask questions of. So usually we would ask questions of the testifiers, but if you'd like to make an opening statement, you're more than welcome.
Okay, good morning, Chairman Rhodes and members of the Senate Judiciary Committee. I thank you for this opportunity to sit before you today as you weigh the confirmation of my appointment for District Court Judge on Maui. I greatly appreciate the time that you all took to meet with me in the run-up to this hearing, but please let me reintroduce myself to you. My name is Chris Dunn. I am 50 years old. I've been married to my spouse, Pualani Enos, for 21 years. Together, we have 3 children, Claire Mehealani, who is 16 years old, Oliver Keahi Ula Okala, who is 13 years old, and Dylan Kaiva Kumaka Opua, who is 11. Pualani and I have lived on Maui for over 18 years, and we are active members of our Maui community, professionally, athletically, culturally, and scholastically through our children. I was raised in Massachusetts with my younger sister, Mara, by our 2 loving and extremely hardworking parents, Paula and Jeff. I come from a family that is devoted to public service. My grandfather was a career police officer. My grandmother was a clerk at the local unemployment office. My father, a career public school English teacher. My mother was a teacher too, for English as a second language class. My sister, a career social worker and high school guidance counselor. My spouse, Pualani, has worked tirelessly with organizations on Maui toward enriching the lives of local children. I have tried to build my career as an attorney so that I can serve the public as well. I have been practicing law for over 25 years, the first 7 years in Massachusetts and the last 18 here on Maui. The focus of my practice is on criminal defense. I have primarily been a sole practitioner, but I have had the opportunity to collaborate with the most skilled and experienced of co-counsel. I handle a high volume of cases and consistently deal with the most serious of felonies. I am in district court or circuit court virtually every day. Approximately half of my caseload consists of indigent clients charged with crimes who I represent on a court-appointed basis. As part of my practice, I handle civil court, family court, and administrative matters as they intersect with my criminal cases. I also serve as a court-appointed commissioner in foreclosures. Throughout my career, I have found my practice to be rewarding, and I do feel that my practice has been a public service. However, that service is ultimately individualized. I hope to be a judge so that I can remain an integral part of the legal system, but better serve the Maui community as a whole. I believe that my temperament and experience make me well suited for the role of district court judge. And if confirmed, I'm excited to serve in that capacity. Again, I thank you for the opportunity to address you today, and I submit myself to any questions that you may have about me or my qualifications.
Thank you very much. Looks like Mr. Ho'okano is here, so I'm going to back up. Mr. Ho'okano, would you like to testify?
Aloha Chair Rhodes and Vice Chair Keoho Kalole. Apologize for the technical issues we had this morning in logging in, but I'm available to answer questions about any procedures that the State Bar Association has when we evaluate our judicial candidates. We did have an opportunity to speak with Mr. Dunn. We had a subcommittee look into his background and interview his references. And after having a discussion with Mr. Dunn amongst the board, we did find the candidate qualified on all of our categories that reflect judicial candidates. With all of that is included in our written testimony and available for questions about our procedures if you have any.
Okay, thank you very much, members. Any questions for Mr. Ho'okano? Okay, apparently not. Thank you very much for your testimony. And we will go back to where we were before, which was Mr. Dunn had made his statement. Members, any questions for Mr. Dunn?
Hi, Chair.
I think we'll go with Senator Favela first, followed by Senator Kim. Go ahead, Senator.
No, Senator Kim can go first. I'm fine. She can go
Okay,
first.
Senator Kim, you go first.
Thank you. Good morning, Mr. Dunn.
Good morning, Senator Kim.
Appreciated having an opportunity to talk with you over Zoom. I just wanted to ask, after the end of this pandemic, there are going to be a lot of cases probably coming before the court regarding payments of rent that was not collected during the pandemic because many renters were relieved of not having to pay their rents and not being evicted. How do you feel that the district courts are going to be able to handle some of these multitude of cases that will probably come before the court?
Well, I acknowledge that there's going to be a high volume of the type of cases that you're talking about. The district court, by its nature, is a high volume case load court. In my experience, in my practice, I have had to handle a high volume of cases on an annual basis. And the way that I've dealt with that is through hard work and familiarity with the cases that I have up and running at any given time. I anticipate that as a judge, it would be very similar in terms of long hours, a lot of research, and being well prepared by studying the caseload that comes up on my calendar on a given day, being familiar with the issues that would be presented and trying to move them along as efficiently as possible. So I anticipate long hours to get through that initial flood of cases that you're contemplating.
You shared with me your hardworking nature, and I think we all appreciate that. I'm more concerned, I think, about the courts itself and how we're going to be able to handle the public and make it also a user-friendly type of court, because with all of the cases that's going to come through, and I'm not even sure how landlords are going to be able to collect any rents because it's people are not going to be able to pay. And I trust there's going to be a lot of evictions coming in, a lot of payments. So is there anything that you see that the district court can do to help to prepare for this instead of only everybody's got to work longer and harder? I think that there's going to be a need to streamline something along the way to anticipate for this anticipated number of cases that's going to come before the court.
As I see district court, basically on a daily basis, we have Judge Hammond and Judge Kobayashi. And for the last year or so, there's been a per diem sitting in district court here on Maui. And despite the pandemic, the volume of cases that district court has been dealing with has not significantly eased. It's just transferred from in-person hearings to Zoom hearings like the one we're having today. And the judges that have been sitting and the staff that have been moving those cases have done so with extraordinary efficiency and also adapting to the pandemic and the transition from in-person to WebEx type conferences. And despite the volume and these challenging circumstances, I have not noticed a marked slowdown in the efficiency by which the court is processing cases. To the extent that trials were literally paused for a period of time, obviously that created a backup. But since trials have reopened, the district court has adapted and just been working overtime and taking care of it. So I do think that there's going to be a higher number of the types of cases that you're talking about. But I think that Judge Hammond and Kobayashi have demonstrated that they're extraordinarily well equipped to deal with that. I hope to lean on them as mentors. I hope to lean, if confirmed, on the staff that has efficiently worked that courtroom for as long as I've been practicing here. And I think together as a collaborative effort, we'll be able to get through whatever challenges are presented.
Thank you. I really appreciate that. But I hope that, instead of keep saying that you guys are going to be able to do it, I hope you have some kind of plan, because in case it happens, instead of being like, well, we didn't realize it was going to be this bad. And that's what happens in government all the time. We don't anticipate some of these things. We don't plan in advance for it. So, the judges have to take on a workload, but it's the public that gets impacted. It's the public gets delayed, and it's people that don't get their payments or aren't able to rent out the units. So I think that that's going to be a big problem. And I hope that the courts will act proactively and at least anticipate what they can do instead of just saying, we can handle it. We've handled it in the past. My last question to you is that there were a number of prisoners released from from prison. The courts put out the list, and we were told 50% of the people that were released committed crimes. What is your take on this? And if you were a judge and this thing happens again, what would be your position on repeating what was done?
When you say if this thing happens again, you mean if there's like another pandemic or something that we have to respond to kind of on the fly?
Release prisoners, yeah.
Well, as a district court judge, I would feel bound by the letter of the law that was in front of me. So in the circumstance you're talking about, the quote unquote law that it would be contemplated would be something that came up in an emergency context promulgated by the Hawaii State Supreme Court that said these class of prisoners are subject to immediate release if they meet certain criteria. The prosecutor's office had
I'm sorry, I don't mean to interrupt. I know we have a time limit, but can you just address how, we're familiar with the whole situation. Can you just address, how would you feel as a judge? Because I've spoken to other judges about it. I've had many of them felt that they'd gone too far, the courts had gone too far. So I was just wanting to know what would your sense?
To a certain extent, I don't know that my personal opinion would be relevant to that policy matter. I would abide by the law that was in front of me. If the law in front of me said, if a person checks boxes A, B, and C, it results in a particular outcome, and the person before me checked boxes A, B, and C, and the law said I had to do something under that context, I would do it. I would feel bound as a district court judge to follow the law. Whether I agreed with that outcome is a different question, but what I would do as a judge is follow the law. And if the law said I shall do something in a certain context, I would do it. If I was conveyed discretion under the law, I would evaluate the particular circumstances of the case before me and weigh the pluses and minuses of the release that you're contemplating and exercise my discretion appropriately.
Okay, thank you very much. Thank you, Chair.
Thank you. Senator Favela, you had some questions? Can't hear you at this point. There you
Oh,
go.
that's okay. I'm good.
Okay.
Thank you.
Thank you. Members, any other questions? Okay, I have a couple to continue on. So as a district court judge, you'll often be getting people who have been convicted of a number of what are considered relatively minor crimes, violations, petty misdemeanors, maybe a misdemeanor or two, are the ones that don't, I guess, ask for a jury trial. Of course, on the individual charge or on individual charges, you just have to look at what you're supposed to block out everything else and just look at the facts of that case. But when you get to the sentencing stage, how will you react if you get somebody who has 10, 15, 20, 60 priors that are all pretty much the same level, no felonies, but a bunch of petty misdemeanors, a bunch of violations? Are you going to deal with that?
I mean, in isolation or in a vacuum, considering you're a hypothetical, I think the fallback position would be to ascribe to graduated sentences. So the individual comes up in front of you on case number 1 and perhaps gets a fine. On case number 2, they get maybe 2 days in jail. Case number 3, 10 days in jail, and so on. So, I think as a general rule, I would ascribe to that theory of graduated sentences in somebody who's consistently reoffending for the same offense. However, I think that you also have to look at the individual's specific circumstance. So you have, it's the number of sort of possibilities are endless, but let's just say in this hypothetical, you have an individual who has struggled with substance abuse, homelessness, and unemployment for a protracted period of time. And during that time, they're consistently driving without a license or driving while their vehicle's uninsured. And now they're before you again in that same context, except this time, instead of driving to go to their girlfriend's house or driving to go acquire drugs or something, they're driving to their work now that they're employed, and they're supporting their family, and they're paying down their fines to try to get their license back in order so that they can be a productive member of society, pay for the registration on their vehicle, pay for the insurance on their vehicle. Those are all things that I would take into consideration in deciding whether a graduated sentence at that point of 30 days or more, whatever the maximum would be, is something that's going to knock a person off a course toward becoming a consistent, productive member of society when they're making a good faith effort to do that. So in a vacuum, I would ascribe to graduated sentences, but I would definitively look at all the sentencing factors that are proposed by, I think it's HRS 706-606 when imposing a sentence, apply those to the specific factors of this person's life, and exercise my discretion appropriately.
Okay, thank you very much, members. Any other questions? Well, let me just add that, sometimes these crimes that are not considered particularly bad, they do have a pretty negative impact on the neighborhoods where they're committed. So I would just emphasize that as you're looking at, assuming you're confirmed when you see cases like that, please look also at the harm to the neighborhoods and to the neighbors that the continuous low-level criminality have. Members, any other questions? Okay, if not, I'm going to, for not to tip my hand on I will be tipping my hand on the second one. We're going to go ahead and delay decision-making for both the candidates, both the nominees, until 10:30 a.m. on Monday, February 8, and that will be via video conference as well. So the DM for both Mr. Dunn and Mr. Rouse will be the DM. The decision-making will be at 10:30 a.m. Monday, February 8. And so Mr. Dunn, if you need to go, that's fine. And we'll see you on Monday.
Okay, thank you.
Moving on to JC number 10. This is James R. Rouse, submitted for consideration and confirmation to the District Family Court of the Second Circuit, which is Maui County for those who are not familiar with the districts, for a term to expire in 6 years. First up for Mr. Rouse. Again, there's a pretty long list of testifiers, but one of them is here anyway, I believe. First up is James Tombe, State Public Defender. Are you here, Mr. Tombe?
Hi, Senator. James Tombe is not in the Zoom room at this time.
Not in the room. Okay, he's in support. David Kane, also in support. Paul Tonninson, Friends of the Children's Justice Center of Maui in support. Ben Lowenthal in support. David Pullman in support. Wendy Hudson in support. Lance Collins in support. William Sloper in support. Peter Horovitz in support. Cody Mina Todani in support. Graciela Dianco in support. Ryan Anderson Toshima in support. Alan Alameda in support. Heather Wolfensbarger in support. Jeffrey Wolfenbarger in support. David Hayakawa, Alan Mason, Richard Singh, Audrey Manor, Sandy Shiner, Fatima Imara, Diane Ho, Sonia Toma, Gavin Doy, Gina Gormley, Brad Sova, Dana Souza, Joseph Toma, Aaron Rosenthal, Brad Paredes, Matthew Combe, Danielle Sears, Aaron Yamashiro, Brandon Siegel, Leanne Galario Guzman, Susan Arnett, Davalin Tingen, Matthew Nardi, all in support. And let's see, is Mr. Tombe, are you here? No, okay. Then next we have Levi Ho'okano for HSBA.
Aloha Chair Rhodes, Vice Chair Keohokalole, members of the committee. Once again, the Bar Association had the opportunity to review Mr. Rouse's application, speak with his references, and a chance to interview Mr. Rouse for this position. After considering everything before us and reviewing the recommendations of our 3-person subcommittee, the Bar Association has found Mr. Rouse qualified for this judicial appointment. And pending your questions, Mr. Chair.
Okay, members, any questions for Mr. Ho'okano? If not, Mr. Rouse, if you'd like to make an opening statement, please proceed.
Senator, thank you, and good morning to all the members of the committee. Thank you so much for all of you that spoke with me individually. I had wonderful talks with just about every member of the community. Senator Ocasio, I apologize that we didn't actually get a chance to talk. I would have bragged to you that both my sisters are retired public school teachers, but I also understand that I think I called you literally day one on the job. So I understand there's a lot of planning to do. I'm humbled by this nomination by the Chief Justice. I'm humbled by this opportunity to be before this committee today and seek your support and ultimately your vote in my confirmation. I owe a lot of thank yous. I don't think I'd be here today if it wasn't for my wife, Mona. I'm very lucky. I got to actually marry my soulmate. And this was a group decision. The magnitude of this job and what it means to our lives was something that I couldn't decide alone. And we had a family discussion, and she agreed that my record of public service would continue in this vein. And I'm very grateful to have her love and her support, the support of my stepson, Tyler, and his wife, Robin, and their two children, Hi'ikua and Lily, who no matter how bad a day I have, I get to come home and see those two little guys, and it just warms my heart to no end. My mother, she's 89 years old. She's the most optimistic person I've ever met. The glass is always half full. My optimism comes from my mom. My sister Christy gave me the love of music. My sister Peggy taught me how to persevere and overcome obstacles and never give up. My brother Tommy, my hero, he's my big brother. He's always been my hero and remains so today. And of course, my father, who left us in 1998, a true believer in helping those who really need your help. The poor, the underprivileged. I couldn't be here today without all of their support. I want to thank Kalani, Roz, and Gil from Maui, the senators from Maui who have devoted their time to public service. They've been so helpful through this process, and I want to thank you all. Every senator that reached out to me, Senate President Cucci, Senator San Buenaventura told me to read Jackson v. Jackson. I did. Hamilton v. Hamilton. I'm in the middle of that. I haven't quite finished that case. Senator Nishihara, Taniguchi, thank you all for reaching out to me as well. To the Judicial Selection Commission, Chair Ronnie Kawakami, thank you for having the confidence in me to put me on the lists for both District Court and Family Court. To Levi Ho'okano at the HSBA for finding me qualified. And of course, to the Chief Justice who had the, trust in me to fulfill this very, very important role and position in our community. At my core, I am truly a true believer in the American experiment. I have studied the Constitution since I was a little kid. I carry it in my pocket. I believe in the values of it. And I'm here to say that I will honor that commitment to the Constitution if I am confirmed. So rhetorically, the question really is what is a judge's role in the community? And to be a judge, I think first and foremost, you have to accept that public service is in fact a calling and a privilege. And essentially of the 25 years in which I've practiced law, I would say about 22, well, actually on Monday, it'll be 22.4 years of public service in both my capacity as a public defender and a deputy attorney general, and also as a prosecuting attorney for a very brief time. A judge is first and foremost a member of the community that they sit in, and their roots must be in the community because that's the community they're serving. Well, I've been on Maui. I came to Maui in 87, 88, the winter of. I worked at the Westin Hotel as a waiter. I ultimately had to go back to the Bay Area for law school, but I got back in 92, where I continued to wait tables more or less until 96. I bartended until I finally, it was a big recession. There were a lot of lawyers on the streets and I couldn't get work as a lawyer, but I always had work within the food and beverage industry, a big part of the community here on Maui. So I think the community can take comfort in that I have had jobs like them. I've got a son who graduated from Lahaina Luna High School, went to Cam Third, Lahaina Intermediate, went to meetings, met teachers, went to baseball games. Have a big love for this community. It's the greatest place to live. I'm so proud to be here. And a judge's job is to bring peace to the community while always minding the impact of public safety and the betterment of the community in which they serve. A family court judge must also protect the children always. That is the number one mandate, frankly. What's in the best interest of this child, the at-risk youth in the juvenile justice system, who I've represented over the years. And it's really a therapeutic court. You can change lives in that court. And I have, and I've been a part of that development of these young people who have gone askew a little bit, and we got to put them on the right track. And I really look forward to that opportunity to assist in changing behavior for at-risk youth. A judge has to be humble, respectful, compassionate, and judicial. You can't play favorites. You must follow the law and the facts to their logical conclusion. I looked at the preamble to the Code of Judicial Conduct, and it talks about an independent, fair, and impartial judiciary being indispensable to our system of justice. And that's my promise to this community, that I will be independent, I will be fair, I will be competent, and I will be courageous. I understand that, there's winners and losers in court. People are upset by the decisions that you make. But that's part of the job. You just have to take the facts and the law as they lead you and not play favorites and not will outcomes based on favoritism. You do it objectively, not subjectively. It's a high volume caseload. But I have been personally dealing with high volume caseloads my whole life. Luckily, I know the clerks, I know the bailiffs, I know the sheriffs, I know all of the court staff that make the judiciary function here in the Second Circuit. We're a unique circuit. We go to Molokai, we go to Lanai. HANA. So we have challenges that other
Sorry to
circuits
interrupt.
don't have.
Sorry to interrupt, Mr. Rouse, but we would like to ask you some questions, and we only have limited time. So if you could wrap up.
Sure.
I'd
I'm
appreciate
sorry.
it. No problem.
Pardon me.
Thank you. You didn't have to wrap up immediately. I was just if that's where you'd like to stop. That's
No, that's great.
Okay. Members, questions? Okay, I have a couple to start with anyway. So there are a couple of fairly unusual petitions that can, well, there's probably more than a couple. There's 2 unusual petitions that could show up in front of you as a family court judge that I wanted to ask you about. First is the Assisted Community Treatment Act, which is a law that if someone is a danger to themselves or others, a judge can order, an interested party can file a petition with family court and ultimately ask the judge to, you know, if they jump through all the legal hoops, ask the judge to order the person to take their meds, and the judge can order them to take their meds short of sending them to the state hospital. Are you okay? Will you follow that law if that situation arises? I know in Maui there haven't been very many of these cases yet, but I hope that at some point that it becomes more routine. So,
yeah, I mean, obviously I have to follow the law. What I do in my present duties are involuntary commitment hearings. I represent the Department of Health, and we petition someone who is, you know, obviously suffering from a DSM-5 diagnosis, that they present a danger to themselves or other folks, and that there's no less restrictive alternative but involuntary hospitalization. The program that you reference has not made it to Maui as of yet. I know it's an Oahu project. I have spoken with the team about ACT, and you know, my understanding is that there's constitutional challenges to it that are being made as we speak. So I know that that's happening, but if the Supreme Court ultimately finds, or the ICA ultimately finds, that it's a constitutional law, obviously I'll follow the law.
I mean, before the yes, there is a case at the Intermediate Court of Appeals, but right now the law has not been declared unconstitutional. So if a case comes before you, you'll.
Oh, absolutely.
Okay.
Black letter law is essential to functioning as a judge.
Okay. Members, any other questions? Senator Kim, go ahead.
Really quick. And this is kind of off the question line of being a judge, but I noticed that you still have a student debt.
Yes.
And it always concerns all of us about, you know, the high cost of student debt and how long it takes to pay. So I was just, you know, surprised that you still have that debt, and that we really need to do something about student debt. So you don't really have to comment. I just raise that concern that, you know, even after you're been working for a long time, that it's hard to pay back that debt. And we really
and I'll just say this, that they front loaded a bunch of interest on me, and I've only been paying principal now for like a year. Everything was interest for almost 20 years. So it's been frustrating, and I obviously have strong opinions about student loans.
Yeah, it's hard to tell that I'm the chair of higher ed, but the same question that I asked Mr. Dunn regarding and you can give us a quick answer about the early release of prisoners.
Well, if a Supreme Court order comes down and says, you know, whatever they're classified, nonviolent offenders, obviously the people who commit violence in the community are the ones you don't let out, unless there's a court order saying otherwise. But the nonviolent offenders, if prioritized by the Supreme Court, I would have no choice but to follow that.
Right, but do you feel that that's a stretch of the court? An overreach of the court?
I don't want to second guess I don't know enough about the issue to second guess it. So
just personally.
I would hesitate to say that.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Members, any other questions? Okay, well, I have one other question. So another petition that can conceivably end up in front of you in family court is a a gun violence protective order. Now, this is a fairly recent law. I think it went into effect at the beginning of 2020. And basically what it says is if there's there are certain classes of people who can file the petition, including people who work with you or your roommates or spouses or law enforcement or someone at school. And if they think that you are having some sort of a psychological or psychiatric breakdown, they can petition the court to have your guns taken away temporarily. It's basically the same question with ACT. Will you, if the right boxes are checked, will you do that? Will you order someone's guns to be taken away temporarily?
Absolutely. Under the standard TRO right now, that's a mandatory provision as well. So if there's a protective order in place, the respondent must turn over their guns immediately. It's unhealthy for mentally ill people to possess firearms. So I would not hesitate whatsoever to remove guns from a toxic situation.
Okay. Okay, members, any other questions? Okay, seeing none, we will be deferring the decision-making on your nomination as well until, let me be sure I get the date right here, 10:30 a.m. Monday, February 8th, and that will be via video conference as well. So 10:30 Monday, February 8th, and we will take the vote in the committee then.
Thank you all for your time today and your consideration. Thank you so much.
Thank you. Thanks for being here, both of you. All right, members, we'll move on to the bill part of the agenda. First up is SB 548. This is a cleanup bill for the vote by mail law that went into effect this last election. Let me find my testifier sheet. First, we have Scott Nago, Chief Election Officer.
The Office of Election stands on its written testimony in support, and we'll be happy to answer any questions. Thank you.
Thank you. Next is Rex Kadila, City and County of Honolulu Office of the City Clerk Elections Division. And I think I butchered your name, sorry.
Support.
Could you repeat that? I'm sorry.
The city stands on its testimony in support.
Okay, great. Thank you. Next, we have Janet Mason, League of Women Voters.
Good morning, Chair Rhodes, Vice Chair Ke'olo Kalole, and committee members. Thanks for hearing this bill. By any stretch of the imagination, the voting by mail transition was a huge success. Probably the most straightforward conversion of any vote by mail program in the country. But there's always room for fine tunings. And so we're very glad that you assembled this bill. You have our written testimony. I'll just mention that we had two suggestions for your consideration. One is that the time for curing deficient ballots be 14 days instead of 10 days, as is proposed in the bill. And the second suggestion was that the election observer program that the state already has be broadened to cover the entire spectrum of election activities, not just counting and poll watching. It's an historical accident, really, that the current law provided for poll watching, but not the full spectrum of activities that is conducted by the city and county. And so we're suggesting that a good cure to the situation is to simply add something to this bill to make the access very good for election observers. So thank you for the opportunity to testify. I'll be happy to answer any questions.
Thank you very much. We'll be doing questions at the end, per usual. James Gashel, National Federation of the Blind of Hawaii.
Thank you, Mr. Chairman and Vice Chair and committee members. I'm James Gashel, representing National Federation of the Blind of Hawaii. And you have our written testimony. I just wanted to mention we offered three small amendments. Well, the first one being that to request an alternate format ballot, which is something that we need if we can't read print. We suggest that there be an option to be able to do that at the time of voter registration, and we have language in the testimony to that effect. We also suggested that language be removed from the new subsection C of HRS 1107. This is section 20 of the bill, which provides for voters with special needs, but subsection C mentions that you can only request an alternate format ballot after the printed ballot has been mailed out. We think it should be at any time. And then the third one is on suggesting voter with special needs advisory committees. And I actually have an error in the testimony. We cross-referenced SB 534. It should have been SB 533, which is the language we recommend for voters with special needs advisory committees. And aside from that, I'll just stand on our written testimony, and mahalo.
Thank you very much. Next, we have Sandy Ma, Common Cause Hawaii.
Good morning, Chair, Vice Chair, members of the committee. We submitted extensive comments in support of this bill. I'd just like to go over a few of them. I noticed that this bill eliminated Election Day as a holiday. We think that may have some unintended consequences of having it difficult to locate voter service centers, which are on government property. That's one. Another one is in section 5 of SB 548 about additional time if you need additional time to register a voter, then a voter is provided a provisional ballot. We don't understand that additional time. It seems to be vague and undefined. We have same-day voter registration. So if we could remove that provision, that would be good. And a third concern is section 6, subsection D. We like that to be reinserted to make sure that people who are removed from voter rolls understand they could register to vote again if they are removed from voter rolls. A fourth concern is section 20. Common Cause's position is that ballots should not be returned by electronic means. That is not secure. That is the position of electronic experts nationwide and by federal enforcement agencies. Issue 5 is that the provision to supposedly add additional voter service centers, I think that is not drawn clearly enough. It would actually reduce the number of voter service centers on election day and the 10 days prior to election day. That is set forth in my testimony. I'm happy to answer questions. And also there's not any provision to talk about drop boxes and adding more drop boxes in which we are woefully below the federal requirements. Thank you.
Thank you. Next is Audrey Suga Nakagawa for Aarp Hawaii.
Hi, good morning, Chair and members of the committee. I'm Audrey Suga Nakagawa. I'm the Advocacy Director for AARP Hawaii, and we represent people age 50 and over and have 145,000 members in Hawaii. We support this measure, SB 548, and would just like to make a comment about Section 22 regarding the voter service centers. We too agree that there needs to be more centers. As evident in this past election, there were a lot of long lines, and so I think this was something that we had been really concerned about prior to the election, about having sufficient centers in different locations of our islands throughout the state. And so we'd like to ensure that that is something that would be considered, especially for our rural communities. We did get some feedback from some of our members who said that there was not a center out in the Windward North Shore area of Oahu. And I can imagine that that would also have been such problems for the islands like for Maui and Big Island. So I just want to make a comment that, you know, we need to really make an effort to ensure that people have access. People don't necessarily drive, especially our senior population, and some do prefer to do in-person voting. So promoting and expanding the access to these individuals along with drop boxes would be something that we'd like to comment and support. Thank you very much.
Thank you. Next, we have Kirby Shaw, Executive Director of Disability and Communications Access Board and Support. Banner Fanene, Common Cause Hawaii in support. Jody Malinowski, Sierra Club of Hawaii in support. Kat Brady, Community Alliance on Prisons in support. Michael Galoyo Jr., LGBT Caucus of the Democratic Party of Hawaii in support. Brandon Young, are you here?
Hi, Senator Rhodes. Brandon Young is not in the Zoom room.
Not in the Zoom room. Okay, he's in support. Brendan Ayolo in opposition. Edith Kawai in opposition. Carolyn Kunitaki in support. Lynn Matisow in support. Playlock Tokuda in support. Marjorie Irway with comments. David Anderson in support. Larry Meacham in support. Edward Hanel in support. Dara Carlin in opposition. Brody Lockhart in support. Lori Boyle in support. John Hendricks, County of Hawaii elections with comments. Jade K. Fountain Tanigawa, Kauai County Clerk in support. And that's all the testimony we have. Members, any questions for the testifiers who are here? Senator Lee, oh, I'm sorry, Senator Gabbard, go ahead.
Thank you, Chair. Question for the Office of Elections. The question is, since the inception of the mail-in voting program, has there been any documented incidences of voter fraud in our state?
We haven't had any documented instances of voter fraud. We did get incidences where people alerted us to social media posts. We did forward it to the proper authority for follow-up, but we haven't had any instance of documented voter fraud.
Thank you, Scott. Thank you, Chair.
Thank you. Just to follow up on that question, social media posts, what kind of social media posts?
So there's people, we've been alerted to social media posts where somebody says they sent us 20 ballots and I voted all 20 of them. We don't know if that was true or not, but we did forward it to the authority for follow-up.
Okay. Members, any other questions? Senator Keo Kalole.
Thank you, Chair. Scott, there is a process in the law to challenge election results based on fraudulent claims. Was your office surprised, or were there any members of the public that followed that process and submitted any sort of substantive evidence to trigger that challenge process in the statute?
So there is in statute contest for cause following the primary election and the general election. Any complainant would file that directly with the Supreme Court. We did have some complaints filed with the Supreme Court, but they were all dismissed.
Can you, to the best of your knowledge, can you apprise us of the reasoning behind the dismissals?
There wasn't any evidence to support their claims. So some of it were, okay.
Oh, go ahead, please.
Oh, so some of it, it was things like a candidate was actually campaigning prior to filing their nomination papers. That is not, there was no proof that that is actually against the law. There were residency challenges in the primary election. It was things like that.
So but there were no challenges utilizing the statutory contest process based off of voter fraud allegations?
Not regarding voter fraud.
Okay, thank you. Thank you, Chair.
Thank you. Members, any other questions? Okay, I'll go ahead and Mr. Nago, I have a few for you, and then I'll see if other members have some. So the bill, the SB 548 that we're looking at here, proposes to repeal language that requires the state to be responsible for paying for all voting system capital equipment. Should this statute be maintained, or does the broader election expenses statute, which is section 11-11-110 or 110, does that broader statute cover capital equipment under its reference to all expenses?
So it does, the broader statute does cover it. So the cost sharing under a vote by mail system would be 50-50. 50% paid by the state, 50% paid by the counties. That statute you are referencing, or that provision you're referencing, had to do with prior prior voting systems where the state would be purchasing the voting system equipment, but also on the flip side, it did say the counties were responsible for maintenance and storage of that equipment. But I think 50-50 is more equitable.
Okay, so you're saying that the section 11-110 gives the counties and the state sufficient maneuverability for people to pay, for the different jurisdictions to pay equitably?
Yes.
Okay. Your testimony suggests amendments to the bill to address administrative issues surrounding the voter registration deadline. Did you have specific language in mind? The quote is address administrative issues surrounding the voter registration deadline. I don't know what page it's on, I'm sorry.
Okay, so the voter registration deadline currently is 30 days prior to the election. This bill proposes to move it to 10 days prior to the election. It would just be a matter of clarifying that you can register to vote via filling out an application or going online and using the online voter registration system, and finally registering at one of those federal and national voter registration act agencies such as the Department of Human Services or Department of Health.
Okay,
so we'll be happy to propose language. Send you the proposed language.
Okay, so this is not just the question of closing the gap between same-day registration and the current system where you have to register within 30 days.
Correct.
Just something else.
It's more because you can also register. There's different ways to register, and we just want to be clear that the voters are aware of that.
Okay, we'll probably be in touch then. Thank you. Your testimony approximates the cost to the state for additional voter service centers. Is this something, are those dollar amounts something that you've already budgeted for?
No, so we are currently budgeted for 8 voter service centers statewide.
How many did we have in the 2020 election?
We had a total of 8 statewide.
Okay, so that's the same number. Okay, so you've budgeted for 8. Go ahead.
And then the number we provided would be per the life of the contract, which would be 3 election cycles per voter service center. So it's a one-time cost for 3 elections.
Okay. So you don't, so your position then is you can't expand the number of voter service centers without additional appropriations.
That would simply be for the equipment used to tabulate ballots in the voter service center. I can't speak for staffing requirements by the county, but that would just be for the equipment to vote.
Okay. Okay, so basically my next question was, do you have the funding to support additional centers? So I guess the answer is no.
We could use federal funds for that, Help America Vote Act funds. It just depends on how many is established by the law.
Is that CARES money, or is that something ongoing?
It's money prior to CARES.
But it's an ongoing program.
It's money we've received previously that we can spend for.
Oh, you still have?
Elections. Yes.
Okay. Okay. Well, then I guess the question is, so do you have enough in that fund to go ahead with additional voter service centers?
So the way the bill is proposed now, we do. But if it gets any higher, I would have to see what the final is. But as it's currently written, we do.
Okay. Okay. Okay, members, I'll open it back up to other people. You have any other questions? I know Chris Lee knows a ton about this because he's the one who was the judge chair on the House side when we passed all mail. No? Okay.
Can you hear me okay?
Yeah.
No, I think you had asked a lot of the stuff that I was going to get at, and really just want to say thanks, Scott, for staying engaged in the discussion and looking forward to the next election.
Thank you.
Okay. Thank you. Members, any other questions, comments? All right, I have some more. Mr. Nago, concerning challenges made at a voter service center by one voter of the right of another voter to remain, or a person to be or remain a registered voter, the bill would add the qualifier that it is to challenge the right of a person to be or remain at a registered voter in that precinct. Does that should that qualification be added, or does the precinct part of it not make any difference anymore?
So I think when you're challenging a voter, the rights of a voter to vote, you can challenge them for two things. One, they're not who they say they are, and two, they don't live where they say they live. So it would have to be tied to the precinct because it would be a residency requirement.
Okay. So I guess the other question that came to mind when we were looking at this is there really any need to be able to challenge people at voting places anymore? I mean, with the vast majority of people voting by mail, you can't challenge them directly anyway, because they're just mailing it in or putting it in a place of deposit. Do we need that challenge provision anymore? And I guess the reason that the other reason I was thinking about it was there were reported incidents in this last election where people were basically trying to bully people in line, and if they have a legal right to challenge, it seems like it gets to be, there's a potential for it getting out of hand. What's your views on just that general provision?
So I think it's a balancing act, like you said, to balance bullying, but it also is a safeguard in the integrity of the election, where if somebody goes in and tries to vote saying they are Senator Rhodes, but they're not, you need some kind of mechanism in there to challenge that voter or potential voter to say that they're not who they say they are.
Okay. Thank you very much, members. Well, I have more. If someone cut in anytime if you want to ask another question. Can I get, let's see, is one of the county clerks here? Someone from the city and county, maybe? Mr. Kadila?
Hi. Yes, Chair.
So you're, okay. Great. The bill allows for additional voter service centers to be established. Do you have an estimate of how much each center would cost the counties, or a county, or more, sorry, be specific, your county, Honolulu?
When we poured over our numbers, we came up with it's about 140,000 for our 2 service centers, just for staffing alone. So that's one of the cost drivers that we have. The other thing, again, I think the chief election officer explain what the other costs would be. So you would have voting system related costs. So you would add that on top of the cost to operate service centers.
So the county's footing the bill on the labor side, and the state's taking care of the capital stuff?
Yeah, actually, the according to Act 136, it's a cost share. So half of that is also
okay. Are additional voter service centers something that your office is budgeting for 2022 and beyond?
Not at this time because of how our budget cycle works, but again, everything's on the table. We are looking at the entire process. One of the things that this bill would allow us is to look at possibly establishing this service centers in a shorter period, possibly less than the 10 days. So that opens up that possibility. But at this time, we haven't identified additional locations or set forth any sort of budgeting.
Okay. So I'm sorry, so I'm going to have to ask my staff something here. Jesse, can you, for the question on your testimony requests the bill be amended to require at least one full duration voter service center in each county. Was that, whose testimony was that?
That testimony was from Mr. Kadia.
Okay, great.
It seemed some confusion about what the bill was requesting, or at least okay. my reading of the testimony.
So my next question, Mr. Kadia, is your testimony requests the bill be amended to require at least one full duration voter service center in each county and the option to establish more at flexible dates and time. The bill proposes to do this on page 31 to 32. Is there other language that you believe is necessary to effectuate that desire?
No, I think, well, the bill currently requires that we run, it separates, right, based on the number of people. I think the neighbor islands can maintain with one full-time and an additional, but in the case of Honolulu, it's been identified that we would have one service center and 3 additional service centers, one of which must be located in Windward, Oahu,
Mhm.
which is a particular and a specific requirement only for the city and county of Honolulu. What we kind of would prefer is a uniform policy statewide.
Okay, understood. Okay, thank you, Mr. Cadillo. Sorry, keep butchering your name. Cadilla, how do you pronounce your name?
Cadilla.
Cadilla.
Yeah.
Okay, sorry.
No worries.
Can I go back to Mr. Nago for a second? So a suggested amendment is to change the time frame to mail ballot packages so that they are received by voters at least 18 days before the election instead of the current approximately 18 days before the election. Do you have an opinion about the suggested amendment?
I think the more time you give voters to receive their ballot, look over their ballot, vote their ballot, and return it, the better for the voter. So by establishing a minimum of 18 days, so they can receive it before, it just depends on how we get the ballots printed, but establishing a minimum of 18 days and allowing voters as much time as possible to receive their ballot, look it over, vote it, and return it is better.
Okay. Do you think there's any liability if we say, okay, it has to be out 18 days before, and then for some reason it doesn't make it 18 days before?
Yeah, that's part of the reason why we suggested we would recommend that it be at least 18 days so that it actually, we would time it so that it gets, we don't want it to be the way the bill is currently written where it says 18 days or approximately 18 days. We want it to be at least 18 days so that if we can send it out earlier, we can.
So you just won't have the problem because you'll just send them early enough that it won't matter.
Correct.
Okay. Okay, one more question. Members, any other questions? All right, I will go on then. For Mr. Nago, a possible amendment is to HRS section 11-108 to allow ballot processing for tabulation to begin earlier. I think right now it says no sooner than the 10th day before the election to no sooner than the 18th day. What do you prefer on that?
So the current law is 10 days prior to election. In the 2020 primary and general election, we used almost all of those 10 days. Looking at future growth in the future of turnout, we may need more time, just because we did run in the general. We did use almost all of those 10 days to process those ballots, and that's starting in the morning and ending at night.
So, Mr. Cadillo, do you agree with that?
Yeah, I mean, we are able to, in coordination with the state, forward all the validated ballots to them. It's not a problem for us to begin as soon as the state requires it. It's no impact on our work. The only thing that we would be concerned with is to allow some time for us to review the first batch, at least, to ensure that there's not any issues with the mailing that would become evident only until we start receiving those ballots. But that's something we can coordinate with the state.
Okay. Thank you. Finally, for Mr. Nago, a suggestion was made to add language requiring the Department of Public Safety to inform persons on probation or parole that they may vote and provide information on how to vote. Is this not already done?
It is done. So anybody who's not incarcerated, so if you're on probation or you're in jail, you are allowed to vote. It's just a matter of us coordinating with public safety to get the message out there that that is the case.
So does that message get communicated now?
Well, we do receive calls from public safety, and we do have to remind them. So it does and it doesn't.
Okay. Is there already a statute that says they're supposed to?
Not that they're supposed to. And I believe there's a statute that says who's eligible to vote, but not necessarily that. I don't know of any statute that says they have to inform. I'm not aware of any statute that says they have to inform those types of people in jail or on probation that they can vote.
Okay, thank you. Sandy Moss, Common Cause, you still here? If additional voter service centers are established, will this create an expectation that voters should vote in person and not by mail? One of the, I think it was Maui County said, do we really want to do more voter service centers? Because then people are going to think that this isn't an all-male election now. What's your views on that?
Thank you, Chair. Common Cause's position is that not everyone has a stable mailing address to receive a mail ballot. So we have homeless, unsheltered, houseless people who have the constitutional right to vote, and they cannot receive a mail ballot because, and we have people who are limited English proficient, who need language assistance, and they go vote in person. We have same-day voter registration, and we need people to be able to access the voter service centers to go vote in person. So those are the reasons we need voter service centers. We have students who first-time voters, studies have shown, who go to voter service centers or polling places to vote in person, to vote in person. So that's why we suggest that there be some voter service centers available to accommodate people who vote in person.
Okay.
It is not to show that we're doing the same. We're not asking for polling places to be reestablished to the same extent as before. We're just saying that there's people with special needs that have to be
okay.
That have the right.
Understood.
Thank you.
Thank you. Okay, members, any other questions on SB 548? If not, we'll go ahead and move on to SB 5. Thank you all the testifiers and all the people, all the members who had questions. Let's move on to SB 550. This is also relating to voting. It would allow an individual who is 17 years of age, but will be 18 years of age on or before the next state or local general election to register and vote at the state or local primary election immediately preceding that state or local general election. Let's see, first up on SB 550 is Lori Nakagawa, Deputy Attorney General, with comments. Janet Mason, League of Women Voters, still here? Oh yeah, there you are, go ahead.
Thank you, Chair. The League supports this bill in the spirit of trying to keep the greatly improved turnout among young people, keeping that going after the 2020 election, that is. We hope that this could be sustained, and we think that allowing somebody who's going to be 18 by the general election to vote in the primary is sort of the forerunner to the general election in many ways. So it is consistent with the current standard of 18. We know that young people are a group that moves often, but we think that if you have the registration and voting occurring pretty simultaneously, that it could be dealt with. We do support having people who are under 18 have a parent or a guardian co-sign when they register to vote. And we hope that you'll pass this measure.
Okay, thank you. Next we have Will Carone, Young Progressive Demanding Action and Support, Dyson Chi with comments, Sandy Ma, Common Cause. You didn't sign up for this bill, but you're here if you want to testify.
Good morning, Chair, Vice Chair, members of the committee. Common Cause provided comments in support of this measure. Thank you.
Okay.
Young people are our future. We support them voting and voting early. Thank you.
Thank you. Next is Dara Carlin, opposition, Jessica Dos Santos in support, Ken Stover in support, Julia Dunville in support, Michael Fenton Stover in support, Van Wishengrad in support, Patricia Blair in support, Joan Gannon in support, Sam Small in support, Marion McHenry in support, Carolyn Eaton in support, Kelsey Amos in support, Gary Hooser, Executive Director, Pono Hawaii Initiative in support, Meredith Buck in support. That's all the testimony we have. Members, any questions for the testifiers who are here? Seeing none, I do have a question for Janet Mason, League of Women Voters.
Yes.
It appears that other states, this bill would restrict the earlier voting to state and local elections only, but it appears from our research, from my staff's research, I can't claim to have done any of it, that other states allow people to vote in federal elections as well. Do you know anything about that?
I only know that there are fewer states allowing voting in federal elections than in just state and local elections. And certainly if the committee is inclined to confidently move forward, allowing this group to vote in federal elections as well, that would be wonderful. But we didn't think there were, that it was the norm for those.
Okay, thank you. Members, any other questions? All right, thanks. We'll go ahead and move on to, we do have a hard stop at 11, so we may be rolling some stuff over, but we'll keep going for the moment. Next up is SB 551, which is the actual constitutional amendment that 550 would require. First up on 551 is Lori Nakagawa, Deputy Attorney General, with comments. Janet Mason, League of Women Voters.
The League supports this bill. I think you have our testimony and happy to answer any questions.
Okay, thank you. Next is Will Carone, Young Progressives Demanding Action in Support. Dyson Chi, testifying for Vote 16 Hawaii with comments. Sandy Ma, Common Cause Hawaii with comments. Brandon Aiello in opposition. Dara Carlin in opposition. Julia Dunville in support. Michael Fenton Stover in support. Van Wishenbrad in support. Sam Small in support. Greg Pupioni in support. Colby Takeda in support. Gary Hooser, Executive Director, Pona Hawaii Initiative in support. And Meredith Buck in support. Members, any questions? Okay, seeing none, let's go ahead and move on to SB 566. This relates to homestead exemptions, would increase the homestead exemption for all persons up to $2 million and require that the real property be the principal residence. First on this is Garrett Marrero, CEO, founder of Maui Brewing Company.
Senator Garrett is not present in the meeting.
Okay, he's in support. Bill Plum, Vice Chair, Collection Law Section of the Hawaii State Bar Association with comments. Neil Okabayashi, Executive Director, Hawaii Banking Association in opposition. Marvin Dang, Hawaii Financial Services Association in opposition. Peter Merriman in support. Russell Adkins also in support. And that's all the testimony we have, and there's no one to ask questions of. So we will move on to SB 612. This establishes the offense of criminal trespass on critical electrical infrastructure. First up is David Rodriguez, Department of Transportation, in support. Albert Cook, Deputy Attorney General. Comments, Jonathan Grims, Hawaiian Electric. Signed up to testify in person. I don't see him. Oh, there you are. Go ahead. Morning.
Laura, Chair, and members of the committee, thank you for the opportunity to provide testimony this morning. Stand by my written testimony. However, I want to make a point that each year we have numerous thefts and damages that affect our ability to provide reliable and safe electricity to our public. So the intent of this bill is to protect the public from providing, entering our facilities and getting hurt or causing theft and damages that our traditional fences, cameras, and security guards cannot. We're also sensitive to the public's right to freely move about and exercise their First Amendment rights. We believe the language in the bill protects First Amendment rights by stating critical infrastructure does not include support offices, land used for the transmission of electricity, or right-of-way that is not completely enclosed and maintained by the electrical utility. So if it's not fenced in, we're not so concerned. We're more concerned about people that are entering our secured facilities, people that cut through the fence or climb over the barbed wire. Those that want to freely pass in front of the facilities or on the easements, that's fine. We're really looking at those that are damaging our system and providing a harm to the system. So thank you very much.
Thank you. Next, we have Gary Lum, Hawaii State Fire Council, in support. Shesere Ka'ava, Maui Fire Department, in support. Mikkel Kunishima, Honolulu Police, in support. Paul Gallagher, in opposition. Kamalani Kaylee Ikuli, in opposition. And that's all the written testimony we have. Members, any questions? Senator Ocasio.
I believe this might be directed towards Mr. Grimm's in respect with what he just had mentioned as the language that makes a little exemptions regarding fenced-in locations. So let's speak specifically of Honua'ola Bioenergy in Hamakua and how that would relate to a civil nonviolent expressing of their concerns and how this would potentially impact the criminal trespass language in this bill.
So peaceful protests outside of the secured facility would not be addressed by this bill. We're talking about people that are actually trespassing to commit a crime. We fully appreciate and respect the right to people's First Amendment right.
Okay, thank you.
Members, any other questions? Okay, seeing.
I got a question.
Oh, sorry. Go ahead, Senator Favela. Just keep in mind we have to stop in like 2 minutes, so go ahead.
Just again, go ahead. I just concerned about this bill because, you know, there already is laws protecting the facility, anti-terrorist laws and all kind of other laws. To put another law in there for these provisions, I kind of called a question. That's all.
Okay, thank you. So members, since we have the hard stop at 11, I was going to defer for decision making a couple of, well, we've already deferred the 2 JCs, so that's for Monday. But I'm going to go ahead and defer everything else for DM. Let me get the time right here, just a second. Okay, so we'll defer DM for the remainder of the agenda, all the bills, to Wednesday, February 10 at 9:10 a.m. And we'll do DM on all the bills other than the JCs. Then the JCs will be on Monday. So our business is concluded, and I'll see you at session and have a good weekend.